Uh, Greetings to you, students. We were disturbed while we were still dealing with the arraignment of the accused in court, and we are still dealing with the part where the accused is asked to plead, right? Because I've told you that the person will be brought to court, and first of all, before anything is done, the presiding officer will ensure that the right person is brought to court by doing that, by asking the accused to confirm his name and surname, right? Then after that, the prosecutor will then prefer charges. By doing what? By saying, Your Worship, the accused is before court, and the accused is guilty of an offense of murder, if it is murder, guilty of an offense of murder, in that on the 24th of July at Mangweni Tavern near Kwazangezwa, the accused unlawfully and intentionally killed an adult male by stabbing him twice on the chest. And then it will also give a brief of what transpired on that day, and then the prosecutor will sit down. After that, the presiding officer will ask questions. The first questions will be, do you understand the charges against you? And the accused will say, yes, I understand the charges against you. And the second question will be, how do you plead? And the accused will either plead guilty or not guilty, right? And then the third part will be where the accused now is read the rights, right? The presiding officer will say, as an accused person, because you are called an accused because you've been accused by the prosecutor. When you entered, you were still a suspect, but now you've been formally charged in court. The charges have been preferred against you. So you are now an accused person. You've been accused of being guilty of a crime and you've pleaded not guilty. So the next step will be for the presiding officer to read the rights, to say, as an accused person, you have three choices. You can choose to be represented by an attorney of your choice at your own cost, or the state will provide you a legal aid attorney to represent you free of charge, or you can conduct your own defense, defend yourself, but the court does not advise accused to defend themselves because there are legal terms that you may not be able to understand. So what do you choose? And they normally choose to be represented by legal aid, or if you have a lawyer, then the accused will say, I choose to be represented by a private attorney. And immediately, because the attorney will be in court, the attorney will stand up and say, good morning, Your Worship, I am Mr. S.N. Dlangamandla, and I confirm my appearance for the accused, and the plea of not guilty is in accordance with my instructions. And then you will sit down. Then the prosecutor, as a person who is dominus litis, will then decide as to what goes on. And he might ask that the matter be postponed, but you must also ask that your accused be admitted to bail as an attorney. And obviously, in most cases, the prosecutor will say the accused cannot be admitted to bail because the investigating officer have not verified his address. That's the normal reason, and that only takes 7 days. After 7 days, they cannot say they have not verified. They have to go and verify the address of the accused so that the accused can be admitted on bail. Right. So we've talked about the pleas that the accused can tender if asked to say how to plead. He can plead that he has received personal pardon, can plead that he is not guilty of the offense, and that the prosecutor has no title. You can plead that he has already been charged, acquitted, or convicted of the charge. There's so many pleas, but most importantly, you cannot plead guilty with any other plea. Plea of guilty goes alone, but you can plead other pleas together. So be careful, look at section 106 and read it carefully. So let us say now the accused pleads in terms of section, because an accused can plead in terms of section 105 capital A to say, I want to do what is called a statutory plea bargaining. Right? What is that? First of all, the requirements for a statutory plea bargaining is that the accused must plead guilty to all elements of the crime, and also that there must be negotiations as to what's the plea bargain. Plea bargain is give and take. You say, if I plead guilty, what will I receive in return? In most cases, you will say, okay, because we have 7 accused arraigned for this charge of murder, one accused, or accused number 1 or accused number 7, is going to plead guilty, but the other accused must be, cases against them must be withdrawn. And the cases will be withdrawn, and there will be only one. And that one accused will do what? Will then go for a plea bargain where he will plead to, you have to plead to a competent verdict or a lesser charge. You cannot agree to a plea where you are charged with murder and then you say you plead guilty to murder. You must plead to a lesser charge. That's what is needed. So that will, what will happen. So now, like I've said, you must plead to all the elements of the crime. Don't have excuses. There are no conditions. You just plead guilty, and also there will be a sentence that is prescribed. That sentence must be read to the record, and whatever you pleaded to, then the court will then confirm that the sentence that has been meted by your attorney, because as an attorney, then you must decide as to what sentence are you going to give to your client. Give him a suspended sentence, or give him a suspended sentence with a fine, or give him a fine only. In a murder case, it happens that a person is fined 20,000 rand, or maybe 5 years in jail. So if they don't pay the 20,000 rand, then they'll go to jail for 5 years. So that's the plea bargain. But in return, that person must also make sure that he does not do some conditions, right? And also the presiding officer has to agree with whatever is contained in that plea, section 105A plea. If there's something that he is not happy with, he's not going to accept it. And what does that mean? Then that means the matter must be done de novo in front of another presiding officer. It can never be the same presiding officer, because this presiding officer has heard when the admissions were made to the record. So he's now got the background information that you, as the accused, have agreed. Because what normally happens is that a person will say, okay, plea bargain. Then if I don't get the plea bargain, then I go back to my plea of not guilty. And he pleads not guilty, and the state fails to prove the matter beyond reasonable doubt, and the person is acquitted. So it's a catch-22 situation. So you need to be very careful. If you have 7 accused in one case, you can make a plea bargain that the other people should go scot-free and only one person can carry the blame, and you go for a plea bargain, right? That's what you need to do. And I will give to your class a precedence or an example as to how to draft a section 105A and a section 112 and section 115. You should use that one. There is one that I'm going to send you. You use that example, because if you do that in practice, you won't have problems. There's another one, section 115 of Mr. Green. You must use that one. And for the section 112, you must do the opposite of Mr. Green's section 115 plea. You just, instead of denying everything, you will be agreeing to everything. Okay, because section 115 is when you plead not guilty. Section 112 is when you plead guilty. Okay, so remember that. Please be aware that you must draft in accordance to what I've given you. You will have the seat of the court, you will have the case number, you will have the parties which will be there, the state versus this person, and then you will say a plea bargain, you will say a plea in terms of section 105 capital A of Act 51 of 1977, right? That will be your subheading, and you draw the 2 lines between this plea in terms of section 105 must be in between 2 lines. So you draw that, and then you start like how I've shown you. That's how it's going to be done. And I will give you an assignment in addition to what I've already given you, where you will be required to draft a plea in terms of section 105A and a plea in terms of section 115 and a plea in terms of section 112. Right? Then you must do that. I will give you the example, but the scenario will be different. Okay, the names and they will be different. So I'm going to give it to you. So let us hold it there for now, before you tell me that I am boring you, right? So you must know what is a plea in terms of section 112 from the procedure area, and also 115, right? And also you must know the basic structure of each plea, right? And also you must know what is called outre fois acquit, and also itre force convict. That is the plea you can make in terms of section 106. So you must read that chapter in its entirety, right? And like I've said, I want you to draft the pleas in terms of section 112, 115, and 105, capital A. Also read the case of Van Wyk, 1981, volume 3, SACR, at page 228, and the case of Shiburi. Citation is 2018, volume 2, SACR, at page 485. Let's read those cases. You can read the case of Mbacha and Fransman, read those, and Carter, read those cases. Then you will know exactly what we are talking out. So please read these cases. Thank you so much. Thank you.